Alex here with a live stream on 6 easy things to do in child custody cases. What I mean by easy is, it's a very relative word to use. For somebody who's never been in the court system, you're going to have challenges from the get-go, just by virtue of not even knowing how the court system works. Typically things associated with what to do, where to go, where hearings are held, what papers to file, how to prepare papers, and things like that. So obviously, if somebody's never used the court system, it doesn't matter how easy something is to do, because for that particular person, they're not even going to get to that question because they're trying to figure out how to even access the court system. But one of the reasons I still wanted to do this video, even though it has this title and it might seem completely wrong to a lot of people in the court system, is because I've noticed a lot of my viewers, most of my viewers, go to court to modify custody. And most of the time, and even more people go to court to modify custody than to actually set custody up. And that's just because so many people settle their cases. A lot of people settle their cases really early, and then they end up back in court when they try to modify custody. And the experience that a lot of people have from modifying custody is so negative that they just don't want to go back to court again for anything else, no matter what. And this is really frustrating for me as a person trying to help people, because some of those people come back with questions like how to deal with splitting their taxes, or how to modify child support. And these things are you'll have a very different experience if you go to court and ask the judge to order that you and your ex split taxes on the children, than if you go into court and ask the judge to modify custody. It's just, the issues are so, I haven't even heard a single person complain about their experience going into court to get the judge to order their ex to split the taxes with them. I hear a lot of people complain that they don't know how to do it. And I hear a lot of people complain that their ex has agreed to split taxes with them. And then they go back on their word. But not anyone who's really said, I went into court to see if I could split the taxes with my ex and the judge did this, this, and this to me. A lot of these people just don't want to go back because of a previous experience that was so bad. So I wanted to go over some of the things, at least in my experiences, because each of these things I'm going to go over are things that I actually went, back to court for. 6 specific things that are a lot easier to get taken care of in court than people think. So again, I'm going to check my chat log, because last time I did a live stream, my chat log wasn't populating. So I'm going to flip this thing around here and see if I can get it going. Let's see. Usually my live streams are usually more interactive, more back and forth. Last time it took like 15 minutes for my YouTube chat to start working, so I'm just trying to make sure that's not a problem again. Let's see. Okay, so the first thing I wanted to mention that in my experience was easy to do in my child custody case is modifying timeshare, not custody, just the timeshare. In my case, it happened 3 times at least. One of them was when my son needed to go to school. So when we initially got our custody case settled, it was a situation, he was just 2.5. So school wasn't, it wasn't a thing to consider. Later on, and he needed to get into school and needed to modify the timeshare. It was a very different experience from what I'd gone through when I tried to take my ex to court for a contempt of court. And of course, through the whole introductory process where you end up going through like the discovery and all those other complex issues. When I asked the court to modify the timeshare, I received almost no opposition from my ex. In fact, she agreed. Her attorney said, he's going to school. We got to change the timeshare. I've heard of people, not in Clark County, a judicial district court, but in other counties where they don't routinely hold hearings. I've heard of people modifying the timeshare and just getting a summary order in the mail from the judge, not even having to go into court. A lot of times this happens when people, like I mentioned, their child needs to go to school, but also because of people whose they change jobs or their schedule at work changes. Little things like this. These are not very difficult issues to get addressed in court. Yet many people are so afraid of the court system because they've never gone, or because they've gone and had a terrible experience that they just don't want to go back. And some of the worst cases, which are really sad, the parent just sends me a message saying that they got a new job and now they never get to see their kids because their ex says, too bad, so sad, that's not my problem. And they're just afraid to go back to court and get the schedule changed. This is not something that's a huge deal. If you got a new job, it's perfectly reasonable to ask to modify the timeshare. Parents that are reasonable parents will just file a stipulation. In fact, a lot of those parents, they won't even file anything. They'll just change the timeshare on their own without going back to court. So if you're dealing with a low conflict ex, most likely it's very easy for them to just go ahead and agree and just modify the timeshare a little bit, send a stipulation in and get it signed by the judge so that your rights are preserved. Or if it's a really low conflict case, which you're probably not on this channel in that case, you don't even bother with court orders in the first place. There's a lot of people out there who will get a court order and then within a year they stop following it. They just work things out on their own. They just ignore their own orders. But for those of us who don't have that situation with our ex, if you file some kind of motion to modify the timeshare because you got a new job or something, that's something that's not going to be a big deal in court. Of course, if your ex files some kind of motion in response trying to do something crazy like hold you in contempt or something like that, it could get more complicated. But the process of changing the timeshare in and of itself is one of the easier things to do. The second thing I wanted to go through was, I already talked a little bit about it towards the beginning, the tax issue. A lot of people ask, how do I get, an order so that my ex can't claim our children every single year? Again, I haven't heard a single person who went into court and had a bad experience. All of the questions come from people who have no idea how to do this, and also from a lot of people who did come to an agreement with their ex, and then their ex just went back on it for whatever reason. So this is something that I did myself. I filed a motion very early on in my case to have my ex ordered to split the taxes with me. By the way, I asked her and she said, no, I'm just going to claim him every year. So I had to file a motion. And it didn't even go to a hearing. Either the judge mailed an order or my ex's attorney just twisted her arm and got her to stipulate. Can't remember which one specifically now. But in any event, I didn't even need to go in and see the judge. The order was just mailed to my house, and voila, I was able to split the taxes with my ex. An interesting thing that I learned here is try to get the judge to order your ex to fill out Form 8332. It's an IRS tax form. IRS tax form 8332 is what the IRS wants. They used to accept court orders in the past. My understanding is that they don't want court orders anymore. Don't send them court orders. I don't even know if they accept them. They want people to fill out Form 8332 and mail that in instead. And that form is like a one-page form, and it specifically states when a parent is allowed to claim a child. So I got that ordered, and my ex filled out Form 8332 and mailed it in. If you're in a situation where you just have a custody order and you don't have Form 8332 as a part of that order, and your ex goes back on it, you can probably have him held in contempt of court. But who knows how hairy that can get, and that's just going to be another court trip. It would be better if the IRS just blocked your opponent from trying to claim the children on those years. The other thing I wanted to say is, in the unlikely situation, and I say unlikely because of how civil contempt works, I'll go into that in a second. In the unlikely situation that the judge does order your ex to prepare and file Form 8332 and they refuse to do so, you can and probably should try and hold them in civil contempt. Civil contempt is where they put a person in jail and they don't let them out until they comply with an order. So I highly doubt your ex is going to want to live in a jail cell for the rest of who knows how long. If they have to choose between going to jail and signing Form 8332 and sending it in, most likely that's what they're going to do. I haven't seen a single person tell me that was an issue. Like I said, a lot of people, it's because they had a handshake deal that their ex went back on, or it's because they did not have a Form 8332 submission, and then they ended up just having a court order, and their ex decided that they wanted to read the court order in a new way, that they decided the interpretation was different. So first thing was visitation, which is easy to handle, just time sharing visitation. Second thing was Form 8332 to get it so that the court will order your ex to share the taxes with you. The third thing is behavioral orders. I didn't hear this term until after my custody case closed, but apparently a behavioral order is just an order that's supposed to police the way that parties go about doing something, create like a procedure, or I'll give you an example. Like, for example, in my case, my ex would not let me go to appointments like medical, dental, vision, and all that. And so I filed a motion to have her order to basically allow me to go to those appointments. Apparently, when a court does this, it's called a behavioral order. I had to do these at least 4 times that I can think of off the top of my head. And each time that I went to do this, it was the least amount of stress possible. with, again, if you haven't seen the beginning of this video, for people who just have never gone into the court system, it doesn't matter what your issue is, you're just going to be stressed out and scared. But once you start to get used to it, there are certain things that are just easier to do, and one of them is behavioral orders. 3 out of the 4 times I filed a motion for an order to have my ex compelled to let me go to appointments, or to give me the medical benefits cards, to give me 14 days notice of appointments. 3 out of the 4 times I didn't even have to go in for a hearing. The judge just mailed an order. That's how low conflict that was. She tried to make it a big deal, but it's not. You're not trying to modify custody or hold someone in contempt. Usually it's not that big of a deal. Usually the courts deal with those summarily. And if it's not what I mean by summarily is without even seeing you, without even holding an evidentiary hearing or a trial, just on your request on the allegations alone. Usually that's what happens. If that's not going to happen, my experience is that the ex's attorney will twist her arm to just get him to just accept whatever it is. When you're asking somebody, can I get an order for you to share the medical benefits cards? No reasonable attorney is going to go into court and say, we can't give them medical benefits cards. That just sounds inane. So these types of things are typically easy to deal with. Most behavioral orders are. Another example was when I needed to set up like a procedure to take turns, because there was so much conflict at appointments. So I filed a motion to see if the court would order us to take turns going to appointments so that we wouldn't both be there at the same time. Little things like that. They're not as big of a deal as people think. The next one is, I'm going to stop right here before I go on to the next screen. Take a look at the comments. We got Brenna Cervantes. Thanks for letting me know it's working. And hi to Willowman. The other parent is threatening to not allow the child to come to visitation if my significant other isn't home. Oh my God, I have a video on this. You know, I kind of think I covered this in the video, Ex's Partner a Bad Influence. The problem with this is it's really hard. You could try to hold an ex in contempt of court for violating your partner's visitation. But the problem is that a lot of times the ex will say, I'm only violating the custody order because he's not there. And it ends up being one of those plausible things that oftentimes with a lot of the nice judges, or especially the green judges, or some of the judges who just don't like to use contempt of court, they end up just letting them off the hook, but ordering from that date forward that you are to allow the other parent to have visitation, even if they're not home, because they're allowed to leave the child with what they call a third-party caregiver in Nevada. Being their significant other, you are a third-party caregiver. You could file a motion for order to show cause and see how far it'll go, but I would probably just file a motion clarifying the involvement of third parties. This is what I did in my case because I had an issue with pickups and drop-offs. Sometimes I needed to send a designee to pick my son up, and I was worried in advance. I was either worried in advance, or I had asked my ex and she refused to do an exchange if I wasn't personally there. So I filed a motion. Again, this is a behavioral order. Filed a motion for the court to basically deal with this issue and say that parties are allowed to send designees to pick up the child at an exchange if they let the other person know in advance. And also, I don't think the babysitter thing came up in my case because that came up separately in the right of refusal war. I call it a war because it went on for like 3 years. I have a video on right of refusal you could take a look at to see how that went. But when I asked the court for the right to send designees, it was such a non-issue. The judge talked about it for 30 seconds. He said, from now on, if you both know who the designee is, you can send the designee instead. So I would say you should do that because you may get lucky and just get an order in the mail and not even have to go in. Whereas if you file a motion for order to show cause to have him held in contempt, it's unlikely with how the judges think. Most judges don't understand high conflict, and they're probably going to say something like, they're probably going to deny it and then say anyway that from now on you can go ahead and let the significant other watch the children. It's one of those frustrating things, Brenna. Anthony Whitehead, thank you for clarifying. And we got Emma Gatewood here. Regarding taxes, my high conflict ex and I have separated but are not divorced yet. I would like for us to file joint married for the last time this year since we will both get more money back that way. Emma, the courts are, I've heard that the courts are, they approve this kind of thinking if the parties agree. So if your ex agrees with you, yeah, let's file it joint and then, split the money. the court's going to go ahead and go along with that. But if your ex says something like, no, I don't want to do that, I want to just file separately, it's unlikely that the court's going to order him to prepare a joint return and sign on the dotted line, just because it's sort of, if two people don't agree, the last thing the court wants to do is unnecessarily entangle them. So you can try and see if the court will order that. First thing you should do is reach out to your ex and see what he says. If you haven't been backstabbed yet, then this is not necessarily a bad idea. If you have, watch my video, Stop Believing the Liar, because a lot of people do go into that deal, Emma, and then they get burned. Like a year later, all of a sudden their ex claims the children. I get most of my messages involving taxes. That's the message, that their ex backstabbed them. They promised to split it, and then they did it. They promised to take turns, and then they did it. So if you think your ex and you can get along and do that, then go ahead and work that out on your own. You may not even have to ask for a court order. If you and your ex are cooperating on your taxes like that, just do it. Brenda Cervantes says, yeah, it's out of state. We buy tickets in advance, and he's a trucker, so it's hard to know. And she filed third party last year. Yeah, Brenda, you should definitely watch my video, Ex's Partner a Bad Influence, because I talk there about the right of parents to leave the children with third-party caregivers. By the way, I also have a separate video on Form 8332 that everyone can take a look at if you'd like to see if I cover any additional details in that video. I think I covered it pretty thoroughly in the live stream, so I just want to let you know that it's out there. That's a video that I did quite a few months, maybe even a year ago. Let's see here. My ex is refusing for no reason other than spite. He has said that even if we agree to file jointly this year in our stipulation, he can still just file single and claim the kids with no consequence. Maybe, Emma, that's a big maybe. He is in violation of court order. If he has agreed, if he stipulated and the judge approved the stipulation, that is in violation. But he might get away with it. You need to watch my video, Contempt of Court, and you need to also watch my video, Gotcha Litigation, because contempt of court is one of those things that the court has a tremendous amount of discretion in, and that is what makes it so hard to predict what a judge is going to do. In fact, if anyone here hasn't seen my video, Discretion, please watch my video, Discretion, because I explain how most of the bias, preconceived notions, ignorance, and incompetence flows from areas of the law where the judges have where the judges have been afforded more latitude, and that latitude comes in the form of discretion. So that's one of the reasons why I'm so hesitant to just say, yeah, they violated an order, go for it and see what happens, because it backfires on a lot of people, unfortunately. The only thing, Emma, that I think you would have him dead to rights on is if he filed jointly and he kept all the money and didn't give any of it to you. I could see that turning into a contempt of court finding. But again, if he has some kind of plausible excuse as to why he doesn't file jointly again, and you can say it's out of spite, but good luck proving it, then it's an unfortunate thing. You may have to, you know what the judge may do if you file some kind of motion for order to show cause, is the judge may just say, you know what, I'm just going to change the order. From now on, you file separately and you take turns. Both of you file Form 8332 and get out of my courtroom. That's probably what's going to happen. Sabrina, you didn't miss anything. We're still going. Emma Gatewood says, oh, I have been backstabbed. I love that video. Yeah, I'm actually going to make a shirt that says Stop Believing the Liar. That's how popular that video is. Joey Dollars, why do I feel that the judge sees me as an unfit parent? Burden on me to prove I'm fit, or is it on them to prove unfit? Keep in mind, I'm the petitioner, haven't seen my son. Okay, Joey, it sounds like you're making a very common mistake. The unfit parent finding thingy, it's called the parental preference doctrine, Joey. Please watch the video, Parental Preference Doctrine, and also watch the video, Your Ex versus the State. When the court is analyzing these cases in the context of a child custody dispute or a divorce action, the state is not impeding on your rights. The state is acting as a mediator between the rights of you and your ex. If anyone is impeding on your rights, it's your ex. And so the whole thing about having to show you're an unfit parent does not apply in these cases. Again, watch those videos if you can. Also, if you want to see an example of where you have to be proven unfit, you can watch the video Guardianship, and you can watch the video Abuse and Neglect Proceedings. Those are different. The context is different in those cases. So let's take a look at the next three issues that I wanted to get into. Issue number 4 is child support. Now, I have to have a disclaimer on child support. The only time child support is easy to deal with is, at least in Nevada, is if your state has formulas, percentage formulas that control precisely how much the court has to award, and also if both parties are working full time. It gets really crazy if one person isn't working full time, because then that opens the door to what they call imputation of income for non-payment of child support, and it makes it more complicated. The other thing that might make it complicated is if one person is owning, they don't work a normal, like a 9-to-5 job, they own a business. If either of these two things apply, it's not easy to deal with child support. But if they don't, if you have two people who are working full time, it tends to be pure math. I modified child support in my case 3 times. It was a little complicated a couple times because my ex kept trying to bring up the imputation of income thing, but really the judge didn't take it that seriously. One of the times I worked at Circuit City and they went bankrupt. So she tried to bring it up and the judge practically yelled at her attorney and said, "Man, Circuit City went bankrupt. So I'm not willfully underemployed if my company went bankrupt." But you know, in other situations, it can get crazy, like with those other 2 examples. Typically, if a person isn't working at all, it gets really complicated, because if a person isn't working at all, sometimes an attorney will try and see if they can count their new partner's income as their income for the purposes of computing child support. And there are 2 or 3 different cases in Nevada that say that that's allowed. The most common example is when like say a husband and wife splits up, and then the wife remarries to another man, and that man works and she's just a stay-at-home mom. And so it can get really frustrating, like if you have joint physical custody, because that mom's income needs to be factored into how joint physical custody into the joint physical custody formulas, and it doesn't work when she's not working because her husband is enabling her to not have to work. And so these cases get complicated. But again, I'm just here to talk about one of the easier things to do. Child support is one of the easier things to do if both people are working full time, because it's pure math. You look at your income, they take the percentages, they compare them to each other, and they spit out the number. Unless there's one person with primary physical custody, in which case they just look at that one person's income. In Nevada, we even have a statute that mandates. Actually, we have 2 statutes that mandate when a judge must consider and review child support. One of them is the 3 years rule. If it's been 3 years since the last child support order, you have a right to have the court consider both your incomes, or your income if it's relevant, and alter the child support if appropriate. The court could consider your incomes and then find that it hasn't hardly changed at all, and then just leave child support alone. That's possible. So even though it's mandatory that the court review child support, it's not necessarily mandatory that the court modify it. It has to be modified consistent with the law. The other example in Nevada is even if it has not been 3 years, you can still get a modification on child support, mandatory modification and review, if you show that your income has changed by a certain amount. I think it was 25%. It may be 20 or 25%, something like that. It's written into law. So if your income has changed by that amount, the court is required to review child support. If not, it isn't necessarily true that the court is not allowed to. It's within the court's discretion. But most judges, they don't want to, you know, unless your income has changed by a lot or it's been 3 years. In Nevada, they're so busy, they don't have time to see you at their discretion. So they'll usually just summarily deny the motion and say, come back when the 3 years is up, or they'll say, come back when the 3 years is up, or if your income has changed by at least this amount. So let's take a look here. We've got a few more comments. Joey Dollars says child support regularly. I'm not sure what you mean by that. Brenda Cervantes says other children and insurance can reduce child support as well. Right, but in Nevada, the insurance is also one of the things that's mandatory, so it doesn't complicate it, because in Nevada, there's a specific statute that says if you're providing insurance, you get a deviation, 50% of whatever premium you're paying per month for the children. So that, again, follows a formula. There's no discretion there for the court. And let's see, we got Sabrina Gonzalez. Would a person get in trouble for still getting child support and having a little time with their son? Basically, I still get paid and I only have 40 hours a year. I'm not sure what you mean. If you could clarify it. It sounds like you're saying you're only working 40 hours a whole year. And would you get in trouble for getting child support? I'm not sure why you would. There's people who don't work at all and they get child support. I'm not sure why that you would be punished for that. Oh, okay. You may be talking about imputation of income. You should watch the video child support. I talk more about how the imputation of income works, at least in Nevada. And that'll explain to you how what you mean by trouble. You might mean, would you end up having your income imputed and then a child support award entered against you? It's possible, but definitely watch that video. Shay says, hey, Alex, and hello all. Hey, Shay. So the next, which is issue number 5, reducing a judgment to arrearages. In Nevada, this was one of the easiest things I came across having to do myself. In Nevada, the way I reduced my ex's child support to arrearages was by following the statutes, which involve sending a letter to her saying, you owe this amount of money, and you can set a hearing within this number of days. The language that has to be in the letter is in the Nevada revised statutes. I had to send it to her registered mail. I sent it to her house. I vaguely recall she didn't respond, so I filed a motion to reduce the child support to arrearages so that I can execute on it and seize it. At that point, her attorney responded, but there was nothing really to say. It was she owed the money, and then she didn't pay it. So the judge went ahead and entered a judgment in my favor, and I was able to collect on that personally. You can watch the video execution to see how I did that. Most people don't do that. Most people just call the Child Support Enforcement Division and let the Child Support Enforcement Division do it for them. It's easier. I think it takes a lot longer, though. So if you go ahead and do it that way, it's just a phone call away. You may be waiting a few months, depending on if your ex is either not working enough or they changed jobs too much, or if you need something complex done. My understanding is that the District Attorney Child Support Enforcement Division doesn't really get that creative with seizing assets to pay your child support. They usually just go after wages or the tried and true method of threatening to throw the ex in jail. If they can't get the wages, they usually just haul them off, try and throw them in jail, and coerce payment that way. But there's a lot of other things you can do out there to try and seize assets. I took money out of my ex's bank account. You should watch the video execution to see just how creative you can be when you're the judgment creditor and when you're able to turn the wheels of seizure and execution yourself rather than waiting for the district attorney to do it. Let's see here. The 6th and final one is make-up time. Make-up time is one of the things that I don't recommend going to court for on its own. Try and lump it into something else. So like if you've been deprived of visitation unjustly, try and lump it into a request for to hold your ex in contempt of court. There are other oddball examples where you can get make-up time. Like, for example, if there was like a blizzard or something and your ex was snowed in and they couldn't get to you, something like that, I suppose you could ask the court to give you make-up time for. But usually it's something that is such a non-issue that even the ex's lawyer will tell him to just give it to you. A lot of times parents will get deprived of 4 days here or a week there or 2 weeks there. And if you end up filing something like a motion to take it to court to get make-up time, most of the time, if your ex is an attorney, the attorney will just twist their arm and tell him to just give it to you because you didn't get your time anyway. If it does go to a court, most judges, make-up time is one of the smallest requests you can make in court. It's one of the easiest things to get. You just explain what days you didn't get, and then the court will count them up, and 9 times out of 10 will give you make-up time. Unless it was your fault in some way, you're going to probably get it. The last thing I wanted to mention about make-up time is if you've been unjustly deprived of time, you can often get 2 days for every day you lost. This is something that I've seen a lot of judges do. So I've seen judges take a motion for order to show cause asking to hold the ex in contempt of court, and then they'll just deny it, and they'll say, I'm not going to put him in jail, I'm not going to fine them, but what I'll do is, you lost 2 weeks of time, so I'm going to give you 4 weeks back. So they'll find different ways. Sometimes they'll get creative about it. But make-up time, again, is one of the most non-issue things you can bring to court. That ends up being all the 6 issues that I wanted to address in the live stream. I'm going to go ahead and try and follow the comments for as long as I can for the rest of the live stream, and then I'll just get on with my Saturday. So let's see here. Sabrina says, basically, shouldn't it stop? I think what you're saying is you're worried that the child support might get stopped because you're not working. It's possible, but it wouldn't be out of punishment. It could possibly happen if the ex argues that you're willfully underemployed for the purposes of avoiding child support, and you're joint physical custody parents. And the court may say, well, I'm going to impute Sabrina's income to 40 hours per week at this amount per hour, and it may end up just being coincidental that it's even with your ex's income, and so child support ends. But it wouldn't be just something like shame on you for not working. I'm taking away your child support. They're not allowed to do that. So unless it happens the way I described, you'll probably be fine. And then, of course, you need to watch the video child support, because income isn't supposed to be imputed just because a person's not working. The court's supposed to consider a bunch of different factors before doing that. The Promised Land, Freedom from Abuse, says, my ex and I are going back to court on the 1st for contempt of court. My ex was behind $10,000 on child support, but he just showed the support agency proof of payment. I'm working on getting those documents. The child support agency should be able to provide them to you. If not, and you think they're relevant, you can use a subpoena. You can watch the video subpoenas to figure out how to do that. But I'm curious if you're the one that's trying to hold the ex in contempt of court, or if it's the actual child support enforcement division that's trying to do that. Because if it's them, the onus is really on them to bring all the proof and to turn the wheels of justice on their own. And so you wouldn't be as involved. You could still, show up at the hearing and maybe say something. But if the child support enforcement division filed a motion for order to show cause to hold them in contempt, then they're going to be the ones that are going to be reviewing all the documentation, and they're going to be the ones that are controlling that process. Just like with a criminal case, if you're a victim of a crime and you report the crime, if the police go and arrest the person and then the district attorney files charges, you're no longer really involved in that process unless they need you as a witness. Same thing with the child support enforcement division. You're not really that much in control as to what they decide to do. And if they do decide to do anything, you're not really in control of the details as to how they decide to go about it. Sabrina Gonzalez says, oh, cool, I have a new member. How did that work? Hey, Sabrina, if you get a chance, tell me how you did that on a live stream. I wonder if there's like a button or something. Let's see here. Let's see. My ex was behind. Sabrina says, no, what I'm saying is that only see my son 40 hours. Oh, you barely see your child, and I still get paid child support, $50 a week. That's odd. Maybe you have primary physical custody of the child on paper. That might be why. If you have physical custody on paper, the court has no idea that you don't see the kids. But if you did try to do something, like if you tried to modify child support, I'm sure that the first thing your ex would say is, she doesn't see the child but for 40 hours a year. So I want primary physical custody. And that could turn into a modification of custody very easily. And that could also turn into a child support order being entered against you. So I see what you're saying now. Yes, if you're being paid child support and you barely see your child and you try to make a big deal out of it, it could become a problem. Not necessarily because child support is that complicated of a thing, but it's because your ex would file something else, a counter motion, and try and deal with your request by collaterally attacking it. So in other words, he doesn't really have much of a defense to your request to modify child support, but he does have a defense, or more so a counterattack, to try and modify the custodial situation entirely. And in that way, he could get around your request and end up saddling you with a child support order. Joey Dollars says, what's worse, being late on child support and missing a reunification, alienation meeting, or not taking child to supervised visitation? You know what, Joey Dollars, depends on the judge. It really does. I've seen a few judges who would definitely become much angrier at the ex who did not take the child to a supervised visitation. But there are some other judges who would just say, you know what, you're both not following court orders. I have a video on this, Joey. I think it's called, it has something to do with depriving custody over non-payment of child support. I can't remember the title of the video, but you should definitely try and find it and take a look, because I go into the details as to what happens when one person withholds the child because the other person isn't paying child support. Oftentimes, both parents are held in contempt of court for violating the court's orders, but not necessarily every time. Usually the court will separately analyze the contempt allegations, and it's possible that the court would say, you're in violation for not taking the child to supervised visitation. You're in contempt of court. Joey, you haven't paid child support, but you showed me it's because you lost your job. So you have an excuse. So even though you're violating the order, you have an excuse here, not held in contempt of court. That could happen. So definitely watch that video. I go into that example a little bit more. The Promised Land says, have you seen this before? I'm curious what will happen if I'm able to prove this is fraudulent. Let's see. Fraudulent, Oh, like if he sent proof of payment that was never made. So you're saying it was some kind of direct payment to you, not through the child support agency, and that you're saying that that payment never happened? Well, if you could prove that, that would be a contempt of court, just by virtue of you being able to prove not only did your ex pay, but he provided fake evidence to the court. Watch my video, Fraud Upon the Court. Providing fake evidence to the court is a big deal. And it may also be considered perjury. I'm not entirely sure, though. Let's see here. Emma Gatewood says, I don't trust him at all. Wondering if I should insist on taxes being filed prior to signing our stipulation, but I worry that if I insist on that, the judge will think that's unreasonable. If we end up in trial, the worst of the worst judges, and I don't think they're in the majority at all, might get upset. These are in the minority. Judges that lash out at you or take revenge on you for not stipulating because they're lazy and don't want to do their job or whatever, they're far and few between. The bigger problem is just general incompetence, because for a lot of judges, it's just a paycheck and they just go to work and they don't really want to get into their job. I talk about this more in Good Judge, Bad Judge in that video. Honestly, I don't think it's going to matter if you haven't prepared the taxes pre-stip or post-stip, because I think in either situation, you're going to have the same problem. Because even if you get him to agree and sign the stipulation, he could just go back on it anyway. And if you try and force him to sign it prior, he could just refuse. It might be easier to just have the stipulation signed if that's the only issue you're concerned about and seeing if it becomes a problem. You're really asking for a lot in trying to get the court to order you guys to file something jointly because you're separating. So the court may find the request unreasonable on its face just for that alone, because you guys are splitting up. So asking your ex to be compelled to file a IRS jointly, even though it's going to be more beneficial to you, it's kind of a big stretch. You may be able to use it in a different way, though. You may be able to use it under the best interest factors. Take a look at the video, Best Interest of the Child. I don't know if you have children because you're asking a tax question, but you may be able to use it to show that he's not willing to cooperate to meet the needs of the child, because more money for both of you would be more money for the children. So it's kind of a stretch all in all to try and have an ex forced to prepare and file a joint return. Promised Land says holding him in contempt. Good. That's good. I like it when people take care of their contempt issues themselves. I feel like it's kind of cheap when you use the Child Support Enforcement Division. I don't know. That's just my opinion, because number one, they're already so busy. And number two, it ends up taking so long. Like I don't know anyone here who's been able to get the Child Support Enforcement Division to do anything within 6 months. Whereas by yourself, you can file that motion and have a hearing within a couple of months in Nevada, at least. So I'm now seeing the new member notifications for member Sabrina Gonzalez. If anyone wants to know what that is, I have a video on what YouTube calls channel memberships. It's very similar to how Patreon works. With Patreon, it's a separate website, and people can sign up and agree to donate a certain amount of money to you per month, like a subscription, kind of like Netflix. YouTube is competing with Patreon by creating a built-in feature that does almost the same thing. It's not as flexible. With Patreon, you can pick any dollar amount you want. With YouTube, if you become a member of the channel, by the way, this is not a specific thing to YouTube generally. This is specific to this actual channel, so you'd be supporting the channel. If you become a member of the channel, it's fixed at $5 per month, so you can't really choose the amount that you want to give. But you are entitled to what they call perks. At this moment, I'm going to be I hate to say this, I'm doing one-on-ones with members right now because there aren't enough members to do an exclusive live stream. When I get to 30 members, that's when I'm going to start doing exclusive live streams. So at this time, that's what the perk is. It's really a temporary thing, though. Don't become a member just for that. Be a member to support the channel. That's what I always say. So the Promised Land says he was also responsible for paying $20,000 in credit card debt. That is in my name almost 2 years ago, and he chose not to. So it's a contempt case for both the support and the credit cards. That's true. That happens a lot too in these divorce cases where they do, what do they call, the division of assets and the division of debts. It happens a lot where the debts get divided and one person just doesn't pay him, and it really sucks because it starts to impugn the credit of both them and the other person. There's all kinds of ways to get around that. Like sometimes a parent can say, you know what, they're not paying the portion of the debt they're supposed to pay. So I'm going to not pay this portion of the debt of theirs that I'm supposed to pay. That's only if you both have debts of each other's that you have to pay. Sometimes one person ends up with most or all of the debt. In that case, you can't even really do that. But I've seen some people get around that with like if there's alimony or child support awards, they might say, hey, I'm going to apply this as an offset to the debt that you were supposed to pay but didn't pay. Definitely watch my video, Offsets and Set-Offs, if you want to know how that works. Worst comes to worst, you've got the motion for order to show cause and try and have him jailed over it. But it's tough because a lot of people who don't pay will go in and say, they won't go in and say, hey, I'm not paying because I want to be a jerk. They'll go in and say, I'm not paying because I can't afford it. And it ends up turning into a really nitty gritty, where's all your money at type of situation. Do what you have to do, of course, but if you can possibly find a way to work around that non-payment, do that instead. So like, again, I'm going to go back into just one example as to offsets and set-offs. Say you're supposed to pay child support to the other person in the amount of $200 per month, and you find out that they haven't paid a credit card bill for the last 3 months and they owe $600 on that. That was a debt that was divided and given to them. You could say, I'm not going to pay child support for the next 3 months because that's 200 times 3, which is 600, and that way I can put that towards the balance of the credit card debt that you weren't paying. Again, I explain how this works in the video, Offsets and Set-Offs. Andrew F., I changed jobs recently and proposed a new parenting plan that not only gave her more time, but also accommodated my new schedule. And she flat out denied me and refused to stipulate. Andrew, this is what I'm talking about. The parents that do this, they just don't know how they're going to look in front of a judge. They're thinking, I want to make your life as miserable as possible. And if you change jobs, that's your problem. Screw you. I don't care about you. Ha ha, now you can't see the kids. That's what it's too common, and you can get that fixed. You're going to just unfortunately have to file a motion. There's 2 ways you can approach it. One way is to file a motion to change the timeshare or the visitation, and you could put in your motion your factual background. I used to work at this company. These were my hours. Now I work at this company. I have new hours. I want to see my kid the same amount of time that I was seeing him before, so I need to change the timeshare. It's a very reasonable request to request to change your timeshare because you got a new job. And it does make your ex look bad. If they don't have a reasonable basis for why they're refusing to alter the timeshare, they're going to look bad. And that's what I was going to go into my second thing, the second approach that you can take, which is an unlikely to succeed approach, but it is possible that you could modify custody based on failure to cooperate to meet the needs of the child. Definitely watch the best interest of the video or best interest of the child video, because I discussed the best interest factors, and one of the factors that's most common in coming up in court is a failure to cooperate to meet the needs of the child. So a lot of times a high conflict ex will think, as long as I'm not violating the court's orders, nothing bad is going to happen to me. Well, you can't be held in contempt of court. That's true. But there are best interest factors that could trigger by you focusing so much on trying to make the other parent's life miserable and thinking you're going to just hide behind, oh, well, I'm following the court orders. In fact, I talk about this exact thing happening to my ex in the video, many fine lines. She tried to go up just to the line to where she thought she was safe, to where she thought she could do certain things and get away with it. What she didn't realize is that in the court system, there are many fine lines, not just one line. And by going up to that one line, the contempt of court line, she inadvertently crossed a bunch of other lines, and I was able to modify custody based on her conduct. Even though she didn't violate a court order, I was able to modify custody based on her failing to cooperate to meet the needs of the child, and also based on her being the source of conflict between the parties. Those are 2 of the best interest factors. Let's see here. Next comment is, hi, the ex is claiming, this is from Hialeah Vet. Ex is claiming that I haven't provided child support since December. I have digital copies of the checks. Should I be worried or am I set? If you have copies of the checks, you're set. Just make sure that you understand I'm not sure if you can use checks as evidence. Normally, you can't use letters and other documentation, but checks might be an exception. There's something, I don't know what the phrase attorneys uses. It's something like records kept during business ordinarily conducted. There's like a magical phrase for certain types of records. I think they may be government records only. So it may not apply to those checks from the bank. You may need something more if it actually goes to a hearing, in like an evidentiary hearing or a trial. You may need a witness from the bank. I would say you should check with an attorney on that, just to make sure that you can rely on the checks alone. You may be able to get around using the bank. You may be able to use the checks as a basis to subpoena your ex's bank account to see if she cashed them. And that would be very useful to you as well. But that might be a little bit trickier because she may have multiple accounts that you don't know about. And so she may provide a bank statement from one account that doesn't show that the checks were cashed. Definitely provide the checks to the court, and especially if you can show that the money was withdrawn. There are still weird allegations that could come up. Something like you prepared a check, you took a picture of it, and then you gave it to your friend who cashed it, took the money out, and gave it back to you. I would not put this past certain exes, like an ex with like narcissistic personality disorder or some kind of severe mental health issue, to do some kind of really weird, convoluted scheme. And the only reason I say that is because something weird happened in my case was something similar, where my ex got 3, what were they called? Money orders. And she claimed that she gave them to me. And she came to court and provided the court photographs of the money orders. And she went and got the money orders, but never gave them to me. It was the weirdest thing I have ever seen my ex do. It was really risky of her to do that. We did check in with the company, Western Union, and the money orders were not cashed at the time of our court hearing. But I have a suspicion that after court, she went and cashed them. Or she could have even just thrown them away just to spite me. She could have went and gotten money orders, which is, it's going to take money out of her pocket, but then just burned them up or shredded them or thrown them away, which is something that a severely personality disordered person would do, because, yeah, they have to pay it, but at the same time, they get to console themselves in the fact that you didn't get the money. Weird things can happen sometimes in some of these really high conflict cases. The ones that I've seen, some high conflict cases where forgeries are provided to the court, where people like prepare a letter from a psychiatrist or psychologist and like copy like a sentence and like put it in a scanner and scan the letter and reprint it with a new sentence added to it. I've seen really weird stuff. So you never know what could happen in one of these cases. Sabrina Gonzalez says, my rights were taken from me 2 years ago, and I'm only allowed to have him supervised visits, and I only see him 1 hour a week, and I'm going to court on that matter. Yes, Sabrina, if your custodial time has been cut down that bad and you're still getting child support, you're pretty lucky, because you don't seem to have physical custody of the child. So I'm not sure how you're getting the child support, but if that becomes an issue, it could really blow up in your face and you could end up paying child support. If the court has made findings of fact and conclusions of law that entitle your ex to most of the custody and just relegate you to supervised visits, it could end up really coming back to bite you if you end up back in court and he decides, you know what, I'm going to ask for child support. Andrew says, I'm now being forced to give up more time every week. She's attempting to dictate when my time starts. Is this denying contact with the child and being a gatekeeper parent? Andrew, that is abusing her right as a gatekeeper parent, and it is denying contact with the child unless she has a very good reason, something like, you know, it depends what she's saying, because I'm only hearing one side of the story. But if she's saying, you know, these are the times available, could you pick one? That's one thing. If she's saying, you can only see the child at this specific time, which I know you're going to be at work for, which I've seen happen. High conflict exes do that. They'll set the doctor's appointments and visions appointments specifically when you're at work, just to spite you. They'll say you can have visitation with the child specifically on a date and time that they know you can't. So, you know, it depends, Andrew. I don't know all the facts of your case. You're going to have to prove those facts to the court. But if you can, that would be abusing her privilege as a gatekeeper parent. Dre says, hey, Alex, guess what? We filed a motion to hold the biomom in contempt of court. Her attorneys filed a motion to withdraw from the case. That is a good sign that she had honorable attorneys. And they have decided that they don't want to represent her anymore. Usually they won't say that's the reason. They'll usually find another reason. They'll say something like, she owes us too much money. She's not paying her bills, and they'll just say, we want to get off for that reason. Or they'll say she's not communicative enough, or they'll say she's not taking our advice, stuff like that. And they'll withdraw from the case. It's a really good sign, Dre, because they may have told her that this is not something you're going to come out, you know, without handcuffs on, so you should just do what they want. And she probably said, I refuse, I'm going to just do what I'm doing. And they probably said, we're done, we're withdrawing off this case. So that's a great sign. Now she is asking us to take custody, and she wants to sign over her rights. Okay, if she's a high conflict ex, if she's got mental health issues, if she's emotionally immature, you might consider taking her up on that offer. If you know, if it's not best for those children to have contact with that person, consider that. You know, unfortunately or fortunately, you could see this either way. In Nevada, you can't sign over your rights unless another parent adopts the child. So you may be required to consent to an adoption of the child for her rights to be terminated under the law. That's a case in Nevada called NRETMC, where the Supreme Court of Nevada decided that. I talk about it in the video Termination of Parental Rights. You should think about that, but make sure it's in the stipulation. Make sure it's all stipulated. What I would probably do if I was you is see if you can get her to sign a consent for adoption. And if she signs it, file a petition for adoption. And then while that petition for adoption is pending, you could ask to continue the hearing in the contempt case, to push it back. And that way you can see if the adoption actually clears. And if it does clear and the decree is entered, then you can vacate that hearing. Let's see. Shay says, the proper person, Alex, there's a link next to the subscribe link under the video right now that has a join in blue letters. Okay, yeah, that is how you join to become a member of the channel, Shay. Thank you for letting everyone know. I didn't know that they show those in live streams. That's why I was kind of surprised. The other thing I wanted to mention for everyone is that this channel has actually been given a special privilege to even have that option. Apparently, YouTube doesn't give this option to channels until you get 30,000 subs. I only have 2,000 subs, so I was pretty excited to see that they extended that to my teeny tiny little channel. Sabrina Gonzalez says, okay, thanks, Alex, but I was able to update my payment method since I was already subscribed. As you remember, I just needed to update. Oh, I see. Oh, interesting how that works. Okay, so apparently they suspended you. And then once you updated it, it just like re-enrolled you. Okay, thank you. By the way, Sabrina, thanks for being a member of the channel. Even though it's just $5 a month, it's a big deal to me because it adds up. I already get a little bit of money from ad revenue, but it's exciting to see the channel membership grow because it shows me that how many people on the channel specifically are more, what's the word they use? The diehard fans versus the other fans. It's okay to be any kind of fan you want, but it does give me a measure as to how many people just view, how many people view and comment, and how many people go so far as to actually join the channel as a member. And I watch those numbers because it tells me sort of what is best, what to continue doing, and what's best practices for the channel for me as a content provider. Joey Dollar says, do judges prefer opposite sex parents or same sex mother and stepmother? I'm not sure what you mean by that. Like, are you talking about LGBT rights? Like for custody rights for LGBT parents? In Nevada, they don't seem to really look at them differently in any way. Clarify if I'm wrong, if I'm not getting what your question is correctly. Let's see. Emma Gatewood says, yes, we have 2 kids interested to use best interest of the child factor. Good idea. I will think about it. I've also heard it could be considered wasteful dissipation of marital assets. Yeah, Emma, if you could be, I think you're right about that. I think we call it in Nevada, I think we call it marital waste. Let's see here. Brenna Cervantes says sexuality. Oh wait, she's commenting to Joey. Let's see. Okay, Dre, if you want to allow the child to have a relationship between the child and grandmother, you have to make sure that that is put into the decree of adoption. At least in Nevada, you do. If it is not put into the decree of adoption, nobody has any rights to those children but you and your significant other. So if you are inclined to let her do that, then you can agree and just make sure it gets put into the decree of adoption. Of course, I'm talking about Nevada, so if you're in another state, it might be different. I think I've mentioned this before, but a lot of these states, they're not necessarily the exact same as the other 49 states, but a lot of times they pull things from each other. So some of these principles that I'm talking about, even though they're specific to Nevada, we may have got it from somebody else, or we may have developed it first and another state got it from us. So the whole concept of visitation rights being included into a decree of adoption may be something that's just out there, out and about, just because other states are, copying that specific statute in the law. So I would check into that to see if it's possible in your state, and if so, if you don't mind it, go ahead and do it. Let's see. Dre says she also says she isn't paying child support because she doesn't know where the money's going. Yeah, that's a very common thing. Most states, now I used to think that none of the states allow you to use that defense, but apparently there are some states like Oregon that allow you to demand a child support accounting. So I think even if she's in a state that allows child support accountings, I think the defense would be get an accounting first and make a big deal out of it. Don't just say, oh, I don't know where the money's going, so I'm not paying it. My ex said that a couple of times. It didn't go anywhere. She looked like a buffoon in court when she said it, because it's just one of the things that deadbeats say. They're just trying to find an excuse. If you really care about where the money is going, don't just say, I'm not going to pay child support because I don't know where it's going. Say, I'm going to file a motion to force you to tell me where it's going. Or say, I'm going to file a motion to modify custody of the child because you're squandering the money. A parent who actually cares about where the money is going will do something to find out where the money is going. They won't just say, nope, no money for you because I don't know where it's just, they're using it as a pretext or an excuse. Andrew F says, oh, and I have a video on that called Child Support Accountings. Take a look at that if you want to get a chance, or if you get a chance. Andrew says, thank you for that answer. We have a hearing coming up that she filed to modify custody. Well, let me know how it goes. If anyone doesn't know about my email address, it's admin@theproperperson.com. Haile Vet says on the back of the checks, it has her accounts where the checks were sent to. Okay, that's good. That gives you a thread to continue on with, doing the investigation as to whether or not she cashed them and where they went to. You should also, hopefully the money's been taken out of your account. If you're bringing up, I have checks, but the money wasn't taken out of my account, that doesn't look good. You could say that she just took your checks and refused to cash them, but it doesn't look good. Hopefully that's not what's going on, because that's very similar to what my ex did with those money orders. And it just got really weird when it came up in court, because the judge was like scratching her head over, why did she prepare these money orders, and why would she prepare them and not turn them in? It was just very weird. Ali says, how much is the cost of writs for temporary orders? In Nevada, we don't have writs for temporary orders. There's not really a cost associated with it, unless you're talking about your attorney's fees for your attorney. A temporary order is, the thing about temporary orders is you're not supposed to just ask for a temporary order out of the blue like that. I have a video on temporary orders. The temporary orders are supposed to be set up because the court needs to set a situation up a certain way up until the trial date. So say you have your child custody action has been instituted and you have a trial 9 months from now. Well, it's great that there's a trial in 9 months, and that's when the court's going to set up the custody situation. But something needs to be set up for the meantime. And so that's the whole point of temporary orders. You're supposed to say, I need a temporary order because I have an evidentiary hearing in 5 months, and there are serious issues here that might be hurting the child. You're supposed to be, or you could say, we need temporary orders because we have our trial coming up and we need something, just to hold things together for the situation right now. But a lot of people ask about just asking for a temporary order just out of the blue like that, and you can't really do that. In fact, the Supreme Court of Nevada is pretty strict about what the definition of a temporary order is. And it can't just be an order that's just been labeled temporary that doesn't actually have some kind of end in sight. Usually, most of the time, the end in sight is some kind of evidentiary hearing where the court's actually going to look at the facts, testimony of the witnesses, submissions of evidence, and stuff like that. So Allie says, X keeps taking the kid to the doctor without my knowledge, doesn't tell me, gives him vaccinations, and acts like there's no tomorrow. Okay, that's what mine was doing all the time in the beginning of my case. I had to file 3 different motions to put a stop to it. So watch my video, refusal of access to medical care. I talk about how I dealt with it in my case. And you could possibly turn that into a legal custody issue as well, though it's harder to do it that way. I have a separate video modifying legal custody. By your ex setting doctor's appointments without your knowledge, they're violating the legal custody principles under the law. because you're supposed to be involved in the process, in the decision-making process. So by keeping you out and just making the decisions themselves, they're violating your rights under legal custody principles. I say principles because there's no specific language in the statute that says you must tell the other person when there's a doctor's appointment. The statute regarding legal custody just talks about, in fact, I'm not even sure if it's a statute. It might just be in the Supreme Court's case law. It just talks about the right to making decisions together and the obligation to make the decisions together as well, and things like that. So that's why I use that word. It's one of the things that's tricky to deal with because it's so hard to hold people in contempt when they violate legal custody principles because they're not technically in violation of a court order. But anyway, in my case, I was able to do both. I was able to get 3 different behavioral orders against my ex for not including me in doctor's appointments, and I was also able to modify legal custody, which ended up solving the problem completely. Because once I had sole legal custody, she was completely cut out of the decision-making process. Whitney Sissel says, how about he has majority of custody after having 25 CPS reports filed on him in 2018 alone? Violates the mediated order of no corporal punishment. Okay, CPS reports mean nothing in child custody case. Anyone can file a report. That doesn't necessarily mean anything came of it. 25 reports, that's not going to help. If findings were substantiated, you might be able to do something about that. But it's not going to happen automatically. You're going to have to end up showing whatever it was that the CPS agency decided substantiated that claim in your actual custody action as well. Sometimes it's as easy as just having the CPS worker testify in your case. Other times it can get really crazy, depending on what the CPS system decided to make its findings on. But in your case, it seems like you're just talking about reports themselves. It doesn't seem like CPS has intervened. I don't know what a mediated order of no corporal punishment is, but the violation of an order isn't necessarily considered abuse and neglect in and of itself. The violation of an order in and of itself can be used to get a contempt of court if you have all the other things supporting a contempt of court claim. Again, it's complicated because of discretion. Watch the video, contempt of court. Also watch the video, gotcha litigation. But those reports alone don't necessarily mean that the custodial situation was set up incorrectly by the judge. Whitney Sissel says, the kid's therapist is blatantly biased. The GAL is also biased. CPS is useless. Okay, so I agree with you on CPS not being the best way to go in custody cases. In fact, I talk about it in 2 different videos. The first video is filing reports. The second video is abuse and neglect proceedings. The reason I tell people not to use CPS in their custody case is because CPS is not a custody court. They're not there for that. Also, CPS tends to take allegations from a parent with a teeny, teeny, tiny grain of salt because they're so used to being used as pawns in custody cases that they become incredibly jaded. And when they find out that a report has come from a parent in a custody dispute, right away you're going to the bottom of the pile and they're not going to take it seriously. And it's not necessarily your fault. It's just that so many people have come to them and lied that it's really hard for them to sort out the liars. So that's why I tend to tell people, if you see abuse and neglect in your case, I say you should just litigate it yourself, modify custody yourself, file the motions yourself, and go in front of the court and prove the case yourself. Don't use CPS. In those videos, I describe other disadvantages to using CPS, one of them being that your ex gets a free attorney, and the second one being that the evidentiary standard is harder. They get to use the clear and convincing evidence standard instead of the preponderance of the evidence standard. You just create so many disadvantages by using CPS. In my opinion, CPS is there for third parties, other people who are not connected to your family, doctors, psychologists, teachers. They should use CPS. They're not intimately connected to the facts of your case, and they're not personally connected either. It's just different. When a parent has a problem with abuse and neglect, I strongly recommend the parent litigates the abuse and neglect issue in their child custody case themselves. I realize CPS is attractive to people because, number one, it's free. You just pick up the phone and call. And number two, it's low stress in the sense that you don't have to see a judge. You just pick up the phone call, hang up the phone, and you let CPS do their thing. Whereas if you go to court, you have to see a judge and it stresses people out and you have to pay all this money. But as you can see in your case, 25 reports, and you ended up with what it sounds to me like just visitation rights. So CPS hasn't gotten you anywhere. And there's another video, another live stream called Viewers Victory #1. And in that live stream, I described a case where CPS didn't help him at all, with I think one exception. But the exception was kind of a wash, because when he ended up litigating the cases, litigating the issue in his own child custody case, one of the CPS workers actually testified in support of his ex. So I don't know. Sabrina Gonzalez says, thank you, Alex. Totally understand. I've tried to stop at several times. I even tried to bring it up in court, but the judge didn't. But the judge couldn't hear it because I didn't file papers. Oh yeah, Sabrina, you can't do that. Okay, so in any state, I think all 50 states, it's a due process issue. In Nevada, I have a video due process, by the way. In Nevada, we are a notice pleading jurisdiction, so the court doesn't have jurisdiction of any issues that you haven't noticed the court and the other party of. It's also considered trial by ambush when you put somebody, when you bring up an issue like that without giving them advance notice. It's not at all like small claims. Small claims courts, as you see on TV, people just walk in and wing it. You just bring up whatever issues you want, see what happens. Normal formal lawsuits don't work that way. It's considered prejudicial to the other side to just ambush them with an issue that they weren't prepared to deal with in advance, because they may have evidence they could bring up. They may have documentation they can bring up. They may have case law that they can cite. They just have most people don't memorize case law. Even lawyers don't. Lawyers might memorize a handful of cases, but for the most part, they know what to look for, but they do need to sit down and look for it. So they do need the time to research. If you just bring something up like that in a hearing without warning them, it feels unfair because they didn't get a chance to go and look it up and research it and stuff like that. CGM Pro, GALs are very biased, especially female GELs. I have a video on guardians ad litem. I have no personal experience with guardians ad litem, the private ones that people use in a lot of these other states. In Nevada, I haven't really heard of people using guardians ad litem in their custody or divorce cases either. I've heard of people using parenting coordinators and custody evaluators, but not guardians ad litem. We do have guardians ad litem that work under the CASA organization, which is the Court-Appointed Special Advocates organization. I'm actually one of them, but we are not appointed to divorce actions and child custody actions. We are only appointed to child abuse and neglect proceedings, basically children in the foster care system. As a court-appointed special advocate, I don't get paid. We go through extensive training and we do our work for free. We're there to help the children because we actually love the children. Not to say that the other ones don't, but I know that it's a very different thing for a GAL who's working as a volunteer versus a GAL who's made a job of it. Who knows, maybe they have better training, maybe they have degrees that we don't have. And of course, they're paid, so maybe that helps them do a better job in some cases, but I don't know. A lot of people say negative things about them. Very few people say positive. And my understanding is that some states use them a lot, like Florida, other states not so much. And it doesn't seem like our state is one of the ones that really uses them that much. With the exception of those other two things, custody evaluators and parenting coordinators. And even those in Nevada, mainly they're used in Clark County. Up in Washoe County, which was where my case was, I didn't hear about them a lot, even those. So Whitney Sissel says, I had a substantiated DNA case 2 years ago that I have completely recovered from. He has taken advantage to hurt me. He's a full-fledged NPD. You could use the diagnosis in your child custody action if you can prove it. You could also use the substantiated case that you have. But again, you're going to have to prove those issues in your actual court case. You probably won't be able to use preclusion, which is something that a lot of people don't know what it is and how it works. What preclusion is you're trying to block your opponent from bringing up an issue or defending an issue because of some legal principle that doesn't allow them to do so. I don't want to get too technical on the live stream. If you want to know how preclusion works, and especially if you are not understanding why your judge is rejecting CPS reports and CPS findings, watch my 2 different videos. Issue preclusion is one of the videos, and claim preclusion is the other video. Also, take a look at the video change of circumstance, because I kind of talk about how claim preclusion ends up playing into child custody actions in most states, and that might be something that's relevant too. But anytime you go to court and you say, because of this, they can't talk about this, and one of the most common examples is because of the CPS finding that's substantiated or unsubstantiated, they can't bring this up. Anytime you're trying to do that, you're trying to use issue or claim preclusion. You just don't know it because you don't know what the legal terms are and you don't understand how it works. And the court is bound by the elements of issue preclusion and claim preclusion. The court isn't just supposed to say, "Oh, you're right, that was unsubstantiated, so you can't bring it up in my courtroom." That's not supposed to happen. And if it does, it's reversible. They can file an appeal and get it fixed. Again, I'm going to try to avoid getting technical on this video. I have videos that go into those details. Shay says, "Kudos to your channel, Alex. I still feel like one of your best videos is the one titled Legal Nuts and Bolts Execution and Asset Seizure." Yeah, most people don't know that's a thing. You're totally right, Shay. It's one of my favorite videos too. Andrew says, "The ex has intentionally scheduled appointments and only told me an hour or so before the appointment while I was at work. So it's a double bind to either leave work and jeopardize my job or miss a spot." Andrew, it's absolutely a double bind. Get that fixed. You watch the video failing to agree. If your ex refuses to agree, file a motion and get it fixed, because that's not good for your kids. And you may, if you have enough evidence, especially if you have other types of evidence that work towards a modifying custody, you could lump that into a request to modify physical custody, because it does hurt your child. You do need to keep your job. So Ali says, "Are there statutes in Nevada requiring the kid to be active and parents to take the minor to do things?" Ali, there are not. My understanding is no. They end up rolling that into best interest analysis, though. Watch the video Best Interest of the Child. Definitely watch my video Extracurriculars, because I talk about how thorny the issue of extracurriculars becomes in high conflict child custody cases. I could go into that for 20 minutes on the live stream if I really wanted to. There are a lot of dynamics when it comes to doing extracurriculars with high conflict exes. It's easy for low conflict exes, because low conflict exes want what's best for their kids, and they will find extracurriculars and they will make it happen. They'll take their kids there, pick them up, they'll be involved. But with high conflict exes, it becomes tricky, because the high conflict ex is exercising their rights as obnoxiously as possible and will try to use whatever weapon they can at their disposal to create conflict and frustrate your rights, or traumatize the child. So sometimes extracurriculars can be used in that fashion by a high conflict ex, which is why I have a separate video on it where I talk about that, how to deal with that and how far you can go with that if you try and take it to a judge and see if you can modify custody or something like that. Houston Clark says, "Is it possible to use strategies when divorcing a narcissist, i.e. look for infidelity evidence?" Okay, Houston, I don't know, because in Nevada, we don't care about infidelity in the court system. I have a video called Custody by Morality. Other states might require the judge to consider infidelity, but ours doesn't. In fact, we have case law where judges' decisions have been reversed because they base their decision on infidelity. So it's the exact opposite of what you're thinking. And in this state, a judge did something based on infidelity and his decision was reversed. And it had to do with alimony. But yeah, I really, and it's hard to say that there's any kind of strategy for divorcing a narcissist, because narcissistic personality disorder does have a specific cluster of identifying factors as to what it is. But ultimately, different narcissists can behave very differently. What you can expect is for the case to be a high conflict case if they decide to fight it. Some of them may not decide to even fight it. And of course, with any high conflict case, you're going to want to deal with all of the principles that I address in my videos: communication, my other video, how abusers win, and my other video, hide emotions from abuser. Also, you should take a look at the video evaluating mental health, since that's kind of what you're talking about. Sabrina Gonzalez says, "Thank you, Alex. Honestly, it's worth every penny. Truly, and for all the people that are watching this live stream, they should really become a member." Thank you, Sabrina, for the plug. I really appreciate it. Transcending Media says, "Child support makes one of the parents a slave with their baby as incentive, period." Transcending Media. These issues, okay, I know it's frustrating, but this channel is here to specifically help people win their cases using existing law the way it's written right now. I have a video titled The Policy versus the Law, where I explain why I try to get out of the academic debates behind what should and shouldn't be a law. A lot of these issues I actually agree on. In fact, if you watch my video, discretion, my video gender bias, and my video MRA and MGTOW, you can see kind of what my opinion is when it comes to these different laws on child support and alimony and stuff like that. So don't mistake my video, which is trying to help people deal with their child support issues, and with me actually supporting the system. Don't mistake it for me thinking that this is the way it should be. Just because I'm explaining the way the system is doesn't necessarily mean that I think that this is the way the system should be. And again, I explained that in the video Policy versus the Law. There's already a lot of channels out there that attack child support, that attack alimony. And I created this channel because I'm trying to help people win their child custody cases, win their divorce actions, win their child support issues with the way the law is written right now, today. And if you go into court and say, you know, I don't agree with child support, I think Title 4D is evil and this and that, you're going to lose. And people are trying to actually win their cases. You can also fight and change the law at the same time as you use existing law to get the best possible outcome from your own case. Ultimately, that's what we're trying to do on this channel. Joey Dollars says, can I file my own motion if I have a lawyer? If so, do I have to use certain language? Joey, you just have to comply with all the same rules that lawyers have to comply with. So you can watch the video motions to learn how to file motions, and you can watch the video representing yourself to sort of get your head wrapped around what it takes to represent yourself. Legalese is another video I have which explains why the legal jargon does actually help. Once you start to actually figure it out, it helps because a lot of law is research, and research is made easier by the Latin and by the specific phrasage that the courts use. It's harder to find what you need in the law if the court uses all kinds of different terms for it. So you can find it so watch my video, Statutes, Rules, and Case Law, and you'll see sort of how to explain the process that I went about finding the authority for the state of Nevada so that I could put that authority in my motion. And what I mean by authority is statutes, rules, and case law. 3 different types of authority. Emma Gatewood says, one more question. Is it your inalienable right to collect child support through CSEB? If you are the one receiving child support, can you insist on collecting through CSEB even if your ex disagrees? Emma, I don't know. I do know that a lot of judges prefer it. A lot of judges prefer it because it's just less work for them. But I don't know if it's your, first off, I wouldn't use the word inalienable because the right wouldn't come from an overarching principle. The entitlement to child support is a pretty new construct that was just created by legislators. They created the right to child support by writing it into the law. So the right would come from the law. You would have to find statutes that basically explain that. Shay says, Joey Dollars, I wrote to Alex to ask that very question. He said no, that you can't file papers for yourself if you have an, oh, sorry, Shay. I didn't know he already has an attorney. Yeah, if you have an attorney already, no, you can't file papers in court. Those are known as fugitive pleadings when you do that. When you have no attorney, you're acting as your own attorney. So you have the powers that any attorney would have, which is direct access to the district courts and justice courts, Supreme Court, and all the rights that the attorneys have, which is to file motions and replies and oppositions and litigate cases. You have all those rights too. But if you have an attorney, you lose those rights because you're not representing yourself. You're not acting as your own attorney. You have an attorney. So that attorney has all those powers. You don't. Whitney Sissel says, I didn't file them. Doctors, coaches, and teachers. Okay, that's good, Whitney. That actually looks good. Because it looks bad when a parent ends up filing 20 or 30 CPS reports. If it's third parties that have filed them and it's not you, you might consider looking into who those third parties were and seeing what their allegations were as well. Because, like I said, you're going to have to prove the case in your own child custody action. And you can't say 25 reports were filed, therefore I should get custody of the child. You're going to have to go into the substance of those issues and try to prove those specific things themselves. Shay says, my attorney is pro bono for me, and in 2 years, I've had only 1 hearing for support. Getting her to file papers is like pulling teeth. Yeah, Shay, it's because they're working for free. I'm imagining anyway, that's probably why. Emma Gatewood says, and can the judge order you to not collect through CSEB? Again, Emma, you know, if this issue came up in my case, I would research it thoroughly because I would be concerned for exactly what you're saying. Unfortunately, I don't have the answers to that. And it did kind of come up in my case. Because my ex didn't want me to use Child Support Enforcement Division, I was kind of okay with not using them because I like just collecting it on my own. But then later on, I got a new judge, and that new judge said, get out of my court, take it to child support court. And she ordered it to go to Child Support Enforcement Division. I ended up not bothering researching whether or not it was appropriate. But it's something that would take research, legal research, to figure out whether or not that the judge has the power to do that. And if so, to what extent can you oppose it? Shay says, will you talk about not being able to file papers on your own if you have an attorney? Yeah, I covered that. Yeah, Shay, I got those questions. No, you cannot file papers if you have an attorney. You're not allowed to do so. There is one exception. You can file a motion to fire your attorney. So if you ask your attorney to get off the case and they refuse, you can file something asking the court to order that attorney to get off your case. Usually that doesn't happen. Usually it doesn't go that far. Joey Dollars says, my first lawyer was $350 an hour for 3 months, and $5,000 later I found another one that took $2K flat. First lawyer said my pics of my son and me was not good evidence because they were 3 years old. I don't even know why they provide those pictures. In my case, those pictures didn't come up. We didn't take pictures of our kid to try and say, look at us, we're great. I really wish judges wouldn't do that. Because anyone could do that. Even an abuse, the worst parent, the worst abuser, the worst neglector could always put on a fake face for a couple of minutes and take a snapshot and show themselves being great with their kids. I don't understand why they consider those pictures at all. In my opinion, actions matter more than photographs. So if you can prove that there's abuse and neglect, focus on the actions and the conduct of the ex and less so on pictures. I don't know. Some judges have cited them before in their orders, not a lot. Luckily, at least in my opinion, it's very few judges that actually seem to put a lot of weight behind the pictures. But I mean, just from having gone through my case, which was high conflict and the amount of abuse and neglect my son suffered, it was not that hard at all for my ex to sit down in a park and take a snapshot. It doesn't prove anything, really. It doesn't matter how fresh the pictures are. Sabrina Gonzalez says, don't see an attorney whatsoever in my situation, wasn't even heard during my trial. Neither was my expert witness, who was a detective, who also wasn't even heard after they talked in chambers. Oh, you know what? I'm not even going to talk about this. I'm just going to direct you to my video Chambers. Sabrina, watch the video Chambers, and that'll answer all your questions as to what happened. Yeah. Houston Clark says it's high conflict, and thank you. You're very welcome, Houston Clark. Candy, hi from San Diego, hi. And do you have an email available where I can ask you a question in regards to my case? Yes, admin@theproperperson.com. I also have a website, theproperperson.com. I'm going to deploy a huge change to my website today or tomorrow, probably tomorrow. You're going to see a whole new layout. It's basically going to upgrade to Twitter Bootstrap 4. Right now it's using Twitter Bootstrap 3. It's not quite as mobile friendly as I would like. Twitter Bootstrap 4 is way more mobile friendly, and I'm excited to get that deployed so that you guys could actually access the site on your phones a lot better. Won't look as janky, I guess you could say. So let's see here. I'm about to end this live stream probably in 5 minutes. I'll take a few more questions. Dre says, do you think the bio mom is just trying to stall the contempt? We asked when she wanted to exchange custody, and she hasn't answered in 2 days. We have court on Tuesday. Oh, wow. She could be trying to continue the case. That's real short notice. You know what? Tell her if she signs a consent to adoption, I don't know, today or tomorrow, then you should consider pushing that hearing back, because the consent to adoption, well, no, they could be revoked. You have to think about it. Trust your gut on it. Also, make sure adoptions work the same way. Watch my video, Adoptions, and I explain how it works in Nevada. Make sure your state works the same way, because that's a lot of research for you to do in a teeny tiny bit of time. I don't know. Think about it. It's a tough call, just because I know how much peace and quiet my son got finally when my ex's parental rights were terminated. So the only reason I'm saying that, Dre, is because what you're being offered is big. If it was something else like, you know, I'll give you more child support, or you reduce child support, or you can have more custody time, I'd say no, just go ahead with your contempt case. But you're saying she's willing to have her parental rights terminated. That's a big offer. So I would look into it, especially if she's abusive and neglectful. If she's not, then maybe it's not a good idea. Maybe she should remain in the lives of the children. But if she has mental health issues or severe emotional immaturity issues, you should think about it. Joy Dollar says, how can I something my ex to communicate with me? We have zero communication. Joey, you can't force communication. You can't. In my case, towards the end, my ex refused to communicate. So what did I do? I filed a motion for sole legal custody. I showed the court all the messages that I sent my ex, that she didn't reply to any of the messages. The court summarily granted my motion and gave me sole legal custody. So if your ex isn't going to communicate, the way to deal with it is through a motion. So watch my video, Modifying Legal Custody, if you want to get all the details as to that. Also, take a look at my video, Our Family Wizard. Dre says, same out here as Nevada, which is good. You did all the research. It's good. Messages to give up her rights are really heartless. You know, it's good that you have the messages. Those messages could be used in your favor later on. It kind of shows that she's really actually gonna. She's not trying to be. She's not trying to be sneaky, because she's putting the messages in writing. So she knows that they could be used against her at a later date to show she's not a good parent. So that just kind of, you know, show that she's willing to actually go through what she's saying. If you end up going to the contempt of court case, or the hearing on contempt of court, and she brings it up saying, you know what, Your Honor, just let him have all the rights of the children, you might consider saying, okay, Your Honor, why don't we hold this in abeyance and see if we can get this done. Just think about it. Andrew says, thank you, Alex, for all your help. I'll be sure to send you an update on your site after our hearing. Oh, thanks, Andrew. Yeah, I'm sure you're going to like it. I'm just excited to deploy it. I'm especially excited to deploy it for my other site, Our Nevada Judges, because that site has a lot of pages that are just not mobile friendly at all. Pages that use grids and tables. And I need to get that upgraded to Twitter Bootstrap 4, especially because some of the people who try to access it on their phones really can't read the data from it very well. CJM Pro, how long should a contempt hearing have to take? I filed a motion to show cause last year in July, and it just had this hearing pass this Tuesday this year. CJM, you're probably in one of those messed up states with an awful court system. A year is way too long. I don't know how your citizenry aren't up in arms and just firing judges left and right. Maybe you just need more judges. Maybe you need more efficient judges. Maybe you need more competent judges, but that's bad. In Nevada, typically it's 2 to 3 months. That's severe. Waiting a year, I can't imagine. I really can't. That's like waiting for an appeal. It's like you file a Supreme Court appeal and you're waiting a year for a decision. That's more normal. That's not even that. I got some of my appeals back in like 6 months. Okay, The Promised Land loves the videos, recommends them all the time. Thank you, Nikki. Thank you for everyone who supports the channel. Thank you for everyone who shares, who likes, who subscribes. Thank you all for viewing. I'm going to go ahead and end this live stream and get back onto my Saturday. All of you have an amazing weekend, and it was great chatting. And hopefully, the beginning of for anyone here who got late or who came late into this video, if you were looking for the 6 specific issues I was talking about that are easier to handle in your child custody case, those are towards the beginning of the video. I spent probably the last 45 minutes to the last hour just sort of following comments. But yeah, if anyone here came late and they want to see those 6 issues as to what's easier to handle in child custody cases, just rewatch the live stream and just probably watch the first 30 to 45 minutes of it. You should be able to get that. So I'm going to put out a video tomorrow and Monday. And yeah, I'm going to go ahead and see you guys next time.